Hello and welcome to this very important session on 100 most expected Maharashtra CET questions. In this session, I am going to discuss with you certain very important principle and fact-based questions, the type of questions which are commonly asked in Maharashtra CET law entrance examination. इन दिस सेशन हम लोग कुछ ऐसे लीगल रीजनिंग क्वेश्चन सॉल्व करेंगे जैसे महाराष्ट्र सीईटी का क्वेश्चन पेपर में आते हैं. So Maharashtra CET question paper, if you see the last couple of years, they have a mixed bag of principle and fact based question as well as legal knowledge based questions. ये दोनों तरीके का क्वेश्चंस आते हैं आपका महाराष्ट्र सीईटी क्वेश्चन पेपर में. इज दैट क्लियर एवरीवन, ऑल ऑफ यू? आई होप दैट you guys are understanding. Fantastic. So guys, let's begin with this session. But before I begin, BYJU'S exam prep brings to you unlock your 3-day free trial access to all our courses. Ace CLAT with BYJU'S exam prep. BYJU'S exam prep also brings to you CLAT 2025 comprehensive course, 380 plus hours of live classes, recorded videos, video solutions of the mock test, practice questions, practice test, study material, doubt resolution, and the CLAT Ignite magazine. The first question is up there on your screen. Read the principle very carefully, read the facts carefully, and tell me what is the correct answer. The principle says every agreement in restraint of marriage of any person other than a minor is void. Rakesh agrees with Yamini that if she does not marry Varun, if she does not marry Varun, Rakesh will give her 1 lakh rupees. Is this agreement valid? Are you trying to restrain someone from getting married? Yes, you are. You are saying that if you do not get married to him, I'm going to give you 1 lakh rupees. Is it any kind of restraint of marriage of a person other than a minor? See, the age of Yamini and the age of Varun is not provided. So we shall think that they are major. They are above 21 and 18 respectively under the law. So the correct answer is the agreement is void. The correct answer is that the agreement is void. Okay, is that clear? Each and every one of you. It's a very simple question. Okay, very good. Devatru, Swati, Divyanshi, very good. Okay, now yes, it is void because there is a restraint insofar as a marriage is concerned. Okay, is that clear? Fantastic. Moving on to the next question. Next principle. Violation of a legal right with or without damage gives right to tort. So the question is whether your legal rights have been violated or not. Damnum sine injuria, injuria sine damno. Remember those two important principles of law to determine liability in law of torts. Damage without injury, injury without damage. Whether you have suffered damage or not is a separate question. The law is not concerned. The law is just concerned about your legal right. आपका क्या किसी भी प्रकार का अधिकार का हनन हुआ है? अगर हुआ है कॉम्पेंसेशन मिलेगा, अगर नहीं हुआ है तो नहीं मिलेगा. Okay. So Sarabhai is a qualified voter in a parliamentary election. But Jatin, the returning officer, wrongfully refused to take Sarabhai's vote. So Sarabhai is a qualified voter, is a legal voter. he is wrongfully refused to vote. No actual loss was suffered by such refusal because the candidate in whose favor he wanted to vote won the parliamentary election. Sarabhai files a suit against Jatin, the person who had wrongfully refused him to vote. Sarabhai is a qualified voter. Is his legal right violated? The question is simple. Is his legal right violated? Read the options and tell me the correct answer. Jatin shall not be liable. Jatin shall be liable. Okay. Jatin shall not be liable. Wrong. Jatin shall be liable. Okay. So between B and D, Jatin shall be liable even if no damages was caused to Sarabhai and there is a violation of his legal right. Very good. Very good. As per the principle, Jatin is liable only if actual loss is proved by Sarabhai. No, this thing is wrong. Option B becomes the correct answer. Injuria sine damno, damnum sine injuria. There is injury, there is a violation of a legal right, but there is no damages, no loss. So option B is the correct answer. Option B happens to be the correct answer. Is that clear? Each and every one of you? Okay. So guys, if you're liking this session, do press the like button. If you're liking this session, do press the like button. Okay. Chalo. So B is the correct answer. Moving on to the next question. Principle. An agreement is void if it is of such a nature that if permitted, it would defeat a provision of law. So, an agreement is void because the agreement is of such nature that it defeats the purpose of a provision of law. Now, let's see the facts. A's estate is sold for arrears to revenue department of the government under the provision of an act of the legislature by which the defaulter A is prohibited from purchasing the estate. So if you have faltered in giving revenue, your land will be sold. You cannot buy your own land. That is the law of the parliament. B, upon an understanding with A. So B and A enters into an agreement where B will become the purchaser and agrees to convey the estate to A upon receiving it. So बेनामी ट्रांजैक्शन, आप खरीद लो, उसके बाद मेरे को बेच देना. Under the law, I cannot buy my property because I have faltered in with some revenue tax. Later on I say कि आप खरीदो और मेरे को वापस दे देना, ठीक है? आप, is it defeating the provision of law? 3. The agreement is valid. The agreement is void. The agreement is voidable at the option of B. No coercion. It is not talking about those voidable things. Agreement is valid as A agrees to pay a valid purchase price to B. No. Option B is the correct answer. Option B. Option B happens to be the right answer. Is that clear? So आप जब भी ऐसे क्वेश्चंस देखेंगे, आप जब कभी ऐसे क्वेश्चन आपके पास नजर आता है, तो आपको क्या करना है? आपको सिंपल एक चीज करना है. आपको प्रिंसिपल पढ़ना है, फैक्ट्स देखना है और बस काम खत्म. Is that clear? Is that clear to everyone of you? Okay? Fantastic. देख लो आंसर क्या है. This agreement is to defeat the objective of the law, that I cannot buy my property. Next question. Question number 4. Nothing is an offense which is done by a person who by reason of mistake of fact, दिया गया है, ठीक है, mistake of fact, not by reason of mistake of law, in good faith believes himself to be bound by law to do it. So it is not an offense if there is a mistake of fact. A, an officer of a court being ordered by that court to arrest Y. So A is asked to arrest Y. After inquiry, he has done inquiry, believing Z to be Y. He thinks that Z is Y. He arrests Z. He thinks that Z is Y. Has he done it purposefully? No. There is a mistake of fact. Even after doing some inquiry, there is a mistake of fact. Fair thought. So what does the principle say? Nothing is an offense which is done by mistake of fact, where the person himself thinks that he is bound by law to do something. The officer is bound by law to arrest Mr. Y. गलती से, mistake of fact से उन्होंने Z को अरेस्ट कर लिया, ठीक है। अब आते हैं आंसर पर, ऑप्शन पे। A has committed the offense, A has committed the offense, A has committed the offense, A has committed no offense. Option D. I don't have to read this part. पहले देखिए, आप लोग जब कभी एक आंसर को सॉल्व कर रहे हैं, कुछ इंपॉर्टेंट चीज प्लीज ध्यान पे रखिए। पहली बात तो यह है कि आप थोड़ा स्मार्ट होना पड़ेगा, क्योंकि सी यू हैव टू सॉल्व 100 a lot of questions, right? Time span is there. So within that time span of 2 hours, how do you solve all these questions faster? और उसके लिए आपको कुछ ट्रिक जानना पड़ेगा, ऐसे आप सॉल्व कर सकते हैं। Is that clear, all of you? Is that clear to everyone? Any doubts? Any doubts? Okay, fantastic, fantastic, fantastic. Chalo. Question number 5. Question number 5. For the purpose of protection of children from Sexual Offences Act of 2012, child means a person below the age of 16 if male, below the age of 18 if female. Any person below the age of 18, any person below the age of 14 if male, below the age of 16 if female, any person below the age of 16. थोड़ा सा कंफ्यूजन लग रहा है, होना क्या चाहिए? Now this is a knowledge based question. Do you have knowledge? If you have knowledge about protection of children from Sexual Offences Act of 2012, you can answer it. If you do not have knowledge, then it becomes difficult. तो ऐसे क्वेश्चंस आपके पास आएंगे, तो आपको अच्छी तरीके से प्रिपेयर करके जाना है, छोटा छोटा कानून के बारे में भी। नहीं तो सी प्रिंसिपल एंड फैक्ट बेस्ड क्वेश्चन, यू रीड द प्रिंसिपल प्रॉपरली, एनालिटिकल रीजनिंग चाहिए, थोड़ा सा क्रिटिकल रीजनिंग चाहिए, बस आपको आंसर मिल जाएगा। बट व्हेन इट कम्स टू लीगल नॉलेज क्वेश्चंस, when it comes to legal knowledge based questions, then it becomes little different, because आपके पास knowledge होने का जरूरत होगा। Is that clear, everyone? Let's see the correct answer. The correct answer is B. Any person below the age of 18. Any person below the age of 18 is a child under the POCSO Act. POCSO Act के अंदर every person, every child means somebody below the age of 18 years. Yes, is that clear? So B happens to be the correct answer. सभी को समझ में आ रहा है? सभी को समझ में आ रहा है? Any questions? So guys, थोड़ा शेयर करो ये सेशन with your friends, so that they can take advantage of these important questions. Question number 6. Principle. When a person makes such a statement which lowers another's reputation in the estimation of other person, that is called defamation. So if you are lowering someone's reputation in the eyes of a third party, that is precisely what we understand by defamation. समझ में आया? सिंपल. आप अगर किसी का रेप्यूटेशन किसी तीसरे पार्टी के सामने लोअर कर रहे हैं, उसको कहते हैं डिफेमेशन. रोहन is in an office party used abusive language against Roman and also states that Roman is a dishonest person. He is abusing and saying that Roman is a dishonest person. Who is saying that? Rohan. Rohan has committed the offense of defamation. Okay. Rohan has committed moral wrong. Rohan has not committed the offense of defamation. Rohan has not committed moral wrong. आपको सिर्फ क्वेश्चन आराम से पढ़ना है और कुछ नहीं, ज्यादा कुछ नहीं करना है, ज्यादा कुछ नहीं करना है. आपको सिर्फ क्वेश्चन आराम से केयरफुली पढ़ना है. इज दैट क्लियर? Is that clear, everyone? All of you? ठीक है? Great. चलो, आपको प्रिंसिपल एंड फैक्ट बेस्ड क्वेश्चन में दिक्कत नहीं होगा अगर आप प्रॉपरली प्रिंसिपल पढ़ते हैं और फैक्ट्स पढ़ते हैं. थोड़ा सा अंडरस्टैंडिंग का जरूरत है. बट व्हेन इट कम्स टू लीगल नॉलेज, एज आई सेड, you have to know. एक लैटिन मैगजिम दे दिया और लीगल मैगजिम दे दिया, आपको पता है या नहीं पता है, आप उधर सोच के कुछ नहीं कर सकते. हु इज द चीफ जस्टिस ऑफ इंडिया? 4 ऑप्शन है. अगर आपको पता है डॉक्टर जस्टिस डीवाई चंद्रचूड़, फिर आप टिक करोगे. उधर कोई रीजन और फैक्ट कुछ नहीं आएगा. वेदर यू नो इट और नॉट is the real question. Is that clear? Every one of you. Okay? Chalo. Moving on to the question number 7. Principle and facts. No one can be punished for the same offense twice. Principle of double jeopardy. ठीक है? Article 20. आर्टिकल 20 में एक चीज है कि नो वन कैन बी पनिश्ड ट्वाइस फॉर द सेम ऑफेंस. उदय is accused of stealing company's data. A departmental inquiry is initiated against Uday. The departmental inquiry finds him guilty and terminates his service. Later on, he is found guilty by a court and he is jailed for 2 years. He claims that he has been punished twice. Now there is a departmental inquiry. And a court punishment. 2 years. और इधर टर्मिनेशन ऑफ जॉब. इज इट डबल jeopardy? Now departmental inquiry is a separate proceeding and a punishment by a court is a separate thing. The law says nobody can be punished for the same offense. He has committed the offense once. Is he being punished twice? No. Departmental inquiry is not punishment under Article 20. Is that clear? Departmental inquiry is not a kind of punishment as enumerated under the principle of double jeopardy. Is that clear? Uday has been punished twice. Uday has not been punished twice. Uday has been punished for different offenses. None of the above. Option B. Option B. Is that clear? Is this clear to each and every one of you? समझ में आ रहा है कैसे आपको सॉल्व करना है क्वेश्चन? एवरीवन ठीक है? In the present case, Uday has not been punished twice for the same offense. Double jeopardy is only applicable in cases which are tried in judicial courts and tribunals. It does not include departmental bodies. Departmental inquiry अलग चीज होता है. It is not a punishment as enumerated under the principle of double jeopardy. Is that clear? Guys, a very important announcement. BYJU'S Exam Prep brings to you other law entrance test preparation, a separate batch for other law entrance test. BYJU'S Exam Prep brings to you CLAT 2025 comprehensive course. Live classes, recorded videos, video solutions of mocks, practice questions, practice tests, study material, doubt resolution, and the CLAT Ignite magazine. All that you will get in the comprehensive course. BYJU'S Exam Prep also brings to you a test series, providing you with 55 mocks, 25 CLAT, 15 ALIT, and 15 OLIT mocks at the most affordable price. So friends, do subscribe to our YouTube channel, follow us on our Instagram, like our Facebook page, join our Telegram channel, and do not forget to download the BYJU'S Exam Prep app today. In case you guys have any doubt, you can raise your doubt in the comment section. I will be more than happy to respond to you. With this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Bye-bye. Take care. Good night. All the best.